Good evening and welcome to this webinar on one of the ELI project. I'm very happy to chair this webinar in order to discuss the ELI proposal for a directive on mutual admissibility of evidence and electronic evidence in criminal proceeding in the EU. We're going to have an excellent panel, first with the two co-reporters of this project that are going to start by presenting the main foundational element and the main rules and principle vertebrating this project. And we are going to follow with a discussion by three excellent experts and speakers that are going to share their feedback, insight, and reflection on the project. So we are going to proceed as follows. I'm going to give the floor immediately after a couple of minutes presenting the essence of this project to the two co-reporters, Professor Lorena Bachmeier-Winter and Professor Farsam Salimi. They are the co-reporters of this excellent project, and they are going to provide you with the basics of the project and the main findings, solution, and challenges. Immediately after that, I'm going to present the speakers that has been invited to share their comment, and I'm going to give the floor one by one and include a very brief introduction of each of them before giving the floor to them. So if I may, Lorena, I would like to give you the floor, and if you are so kind to present the basics of the project, sharing the presentation with Farsam at the time that you consider more appropriate. Please, the floor is yours.
So thank you very much, Teresa, for this very nice introduction and also for chairing this panel. Thank you everyone that has been able to join. I know there are so many events running around, so taking the effort and the time to listen to this project, it's a real pleasure for you having you on board. And in order to give you a brief overview of what we have been doing these last 2 years, 2.5 years almost, regarding this very nice, I think, and very well handled by ELI project on mutual admissibility of evidence. Farsam and me, we have been working shoulder by shoulder all together these last years. I will just give a very short introduction, and leave the floor to Farsam so that he gives you on a good view of all the context and the text of this proposal of a directive. So the idea was to, and this was the aim and the project we presented to ELI, to present a legislative proposal aiming to provide guidance on future European Union legislative action in the field of mutual admissibility in criminal proceedings, to harmonize the approaches in member states, and obviously enhancing the principle of mutual recognition, which is one of the leading principles in cooperation in the area of freedom, security, and justice, and obviously creating this single area of freedom, security, and justice, enhancing and protecting or granting protection of human rights of the suspects and accused, but also to the victims, so other parties of the criminal proceedings. So at present, what we realized, and we asked for different national reports, even if there are already a lot of literature on exclusionary rules of evidence and admissibility of evidence at the national level, we wanted still to have updated information from several countries. So we realized what we already, so to say, suspected, that each European Union member state follows its own rules on criminal investigative measures for evidence gathering. And this results obviously in different standards for its admissibility. The problem is when even in a time when cross-border evidence was not that common, it could be in a certain way admitted that each member state provided for different rules or for different principles on admissibility of evidence obtained abroad. However, in a digital world where electronic evidence is present in almost every criminal investigation, we realized that it was not anymore acceptable first to allow each member state to decide when or when not to admit simply for being gathered abroad evidence that was in compliance with human rights standards. And on the other side, we realized that if there were rules on providing principles for the admissibility, this should be accompanied with ensuring also the defense rights and elevating the standards. And since regarding the most of evidentiary materials and evidentiary measures, there's a long-standing tradition. It was impossible to provide a clear rule and clear regulation on each and every investigative measure, realizing and being pragmatic that this would not be accepted in any way by the member states. But in an area like electronic evidence, where many states don't have a specific regulation, since they are either in the way of implementing or they have just implemented rules on electronic evidence, it was possible to provide guidance, also to say a certain harmonization regarding how to gather electronic evidence so that in transferring from one member state to the other, that evidence should not be lost for the sake of the prosecution, but also ensuring that the same standards could be applied in every member state. And so this is more or less what we have tried to do with this proposal of a directive. And while we were working on this, the EncroChat case, also the Sky ECC case, for those who are not very familiar, you know that the EncroChat case has spread all over and has really raised the problems on admissibility of cross-border evidence all around the European Union. This was a case where the infiltration by French intelligence into a messaging service, the EncroChat service, which is an encrypted messenger service, has led to over 800 arrests and multiple prosecutions across Europe. And this case has highlighted the problems of accessing and using criminal evidence in a cross-border scenario, because this evidence was gathered without a single person targeted in France under French law, but the information that was gathered by infiltration in this messaging system was then spread around and shared with all other, I would say not all other, but most of the European Union law enforcement agencies and prosecution services. So the case is so actual, I would say, and so illustrative on the problems that are being discussed right now arising in practice, that it already has triggered the filing of a preliminary reference to the European Court of Justice by a German court, a court in Berlin. And this court has asked, among others, whether the transfer of evidence obtained without probable cause in a foreign country is in accordance with European Union law. Because for these measures, infiltration into a messenger system, so interception of communications, without a concrete suspicion would in principle not be allowed in Germany according to the level of Anfangsverdacht, although the transfer has been admitted by German courts under European investigation orders. So for those prosecuting these type of cross-border criminal cases, the issue is whether such evidence will be admitting. And this is causing major concerns for anti-drug prosecutors, because we are talking about serious organized crime organizations. And on the other side, if it's not admitted, it could hinder the prosecution of hundreds of members of organized crime groups. So this case clearly shows why some evidentiary rules are necessary at the European Union level. And this has been our aim and our struggle to provide this set of rules, but not imposing new exclusionary rules of evidence to the member states, because we consider this is so much linked with their own conception and the own model of the criminal proceedings in each member state. What we have tried to focus is in elevating to a supranational level the rules that have already been provided by the European Code of Human Rights, and on the other side, provide rules on electronic gathering of electronic evidence, which after the studies we carried out and the national reports we received, we realized that they all follow more or less the same ISO standards or guidelines in every member state. So for the member states that in principle were very much against any kind of introduction of exclusionary rules of evidence or opposing to any kind of limitation to the member states to decide which evidence they will accept or not, they could be really, really very calm and accepting this as a step forward in advancing harmonization, but not intruding or altering the criminal procedure model in any country. So striking the balance between efficiency in prosecution while protecting human rights has been our aim. And we think, as Farzam will present now in detail, we think that some balance might have been struck because no one is completely satisfied with every type of rule. Defense lawyers wanted more protections, while prosecutors wanted to have more leeway on this. So with this, I stop talking, and I hope I was not too late. Thank you for chairing again, Teresa. Thank you, ELI, again. And please, Farzam, the floor is yours.
Thank you very much. Katja, could you start the presentation, please? Thank you very much. Dear Teresa, ladies and gentlemen, dear colleagues, thank you, Lorena, for this great explanation of the background of this project. And it's now my task to explain the details and go into the details. And it's a great pleasure for me to present the results of this ELI project. The result is a proposal of an EU directive, as Lorena has explained, on admissibility of evidence in general and admissibility of electronic evidence in special. The proposal was developed in many meetings and discussions within a large international team, which you can see here on the slide, and to which Lorena and I as reporters are greatly indebted. And what is it all about? And Lorena has mentioned it before. Today, criminal phenomena as well as criminal proceedings are hardly bound by national borders. And this does not only concern organized crime, hate crime, or cybercrime, but nearly each area of crime. The rules on the admissibility of evidence in criminal proceedings, however, as we found out in our national reports, are more or less national. And this naturally inhibits the emergence of an area of freedom, security, and justice, as well as effective criminal proceedings based on fundamental rights. At the same time, there is lack of harmonized rules on the handling of electronic evidence. And due to the overwhelming importance of digital evidence and electronic evidence in nearly every criminal proceedings, there is urgent need for action on an EU level, I think. The present proposal aims to achieve both goals, establishing basic rules on the cross-border handling of evidence on the one hand, and implementing specific rules on the handling of electronic evidence on the other hand. Due to the short time frame, I may only highlight some of the central contents of the draft directive. So let's go to Article 1. This article describes the content as well as the objective of this directive. The directive has two objectives, as I described before. First, establishing general rules on admissibility of evidence between member states and implementing already existing standards set by the European Court of Justice and the European Court of Human Rights in a EU directive. And second, defining more detailed minimum standards for the admissibility of electronic evidence in special. So let's go to Article 2, which defines the scope of the application of the directive. The provisions of the proposal are applicable to evidence obtained in criminal proceedings and those gathered in administrative proceedings. So we want to ensure a high level of or high standard of legal protection, even if the evidence was not obtained in formal criminal proceedings in a member state, but is nevertheless to be used in criminal proceedings. And this is to prevent circumvention of the judicially guaranteed standards by obtaining evidence in administrative proceedings. I will skip Article 3, which contains some key definitions, also definitions of what is electronic evidence. Maybe we can discuss it later. And move to Article 4, one of the key provisions of this draft. Article 4 contains general rules on the admissibility of evidence, including electronic evidence. So it's a general provision. According to paragraph 1 of this article, member states shall ensure that evidence obtained in accordance with the rules of the state of its obtaining, which we call lex loci, may also be used in criminal proceedings in the forum state. The principle of the general usability or admissibility of lawfully obtained evidence should only be broken if its use in the respective member states would violate fundamental constitutional principles of the forum state. Paragraph 2 of this article stipulates that as a rule, evidence may not be transferred to other member states for use in criminal proceedings if it has been obtained contrary to the law of the state of obtaining. Nevertheless, in case there are sufficient guarantees in the forum state that the proceedings as a whole will comply with the principles of a fair trial, the transfer should be admissible. Paragraph 5 of this article contains a general principle of proportionality. Member states should ensure that the use of evidence is generally allowed only if and to the extent that the interference with the fundamental rights of the person concerned is proportionate. Article 5 and 6 define cases of inadmissibility of evidence, whereas Article 5 contains absolutely inadmissibility rules, such as violations of the prohibition of torture and inhuman or degrading punishment or unacceptable coercion to self-incrimination or deception. So standards that has already been set by the European Court of Human Rights. Article 6 contains rules of inadmissibility of evidence that allow for some exceptions in certain cases. Article 7 and 8 especially deal with electronic evidence. The aim of Article 7 is to establish uniform minimum standards for the use of evidence, electronic evidence, in the member states that take into account the specificities and risks of the use of electronic evidence. For example, electronic evidence should only be used in criminal proceedings if it is ensured that the evidence at the time of its use corresponds to the state in which it was obtained, which we call principle of authenticity. Furthermore, it should be ensured that the evidence is also unchanged in its volume between extraction and use in the judgment, which we call the principle of completeness. And finally, it should be ensured that the evidence was sufficiently secured against falsification and manipulation between production and use. So the chain of custody should be ensured. The guarantee of these principles can only be achieved in each member state through some procedural rules. The exact form of this is to be left to the member states. However, Article 7 stipulates some benchmarks to ensure minimum data security standards. And Article 8 contains more detailed technical rules that should ensure more data security, as Lorena has stated before. Let's go to Article 9. Sorry for being so very brief, but I have not much time to present the results. Article 9 addresses the issue of access to electronic evidence. If the evidence is secured by biometric access barriers, such as fingerprint or facial recognition, as we all know, most of electronic devices have such areas, it may appear necessary from the perspective of the law enforcement authorities to use coercion to gain access to these devices. This can be done by holding an individual's head to start the facial recognition or guiding their finger towards the scanner. And Article 9, paragraph 1 states that member states may only consider such use of coercion to be permissible if it is both proportionate and based on a judicial decision. Evidence produced contrary to the prohibition in paragraph 1 should not be used in criminal proceedings. So judicial warrant and the proportionality of physical coercion are cumulative requirements to the lawful production of such electronic evidence. The requirements of this directive are to be enforced by effective legal remedies. So we come to Article 10. And Article 10 stipulates that both the suspect and the accused must be granted access to effective legal remedies against the measures for obtaining evidence, as well as to the decision regarding its admissibility or non-exclusion from the file. This applies to the different stages of the criminal proceedings. And Article 11 establishes minimum requirements for legal remedies to be considered effective for the purposes of this directive. A legal remedy will be considered effective on the one hand if evidence obtained contrary to the provisions of this directive is deleted from the investigation file by the criminal investigation department, the public prosecutor's office, or the court, and in this way cannot find its way into subsequent decisions and subsequent procedural stages. On the other hand, it shall also be considered effective if the judgment based, at least in part, on the evidence obtained in violation of the provisions of this directive can be effectively challenged. Well, these were the most important key points in the proposal. In brief, sorry for being very fast. Thank you very much, and very much looking forward to your contributions and to the discussion. Thank you very much.
Thank you very much, Lorena and Farsam, for this very clear and insightful presentation of this project that we are going to have the opportunity to contrast with the contribution of other speakers, and then we can discuss in more detail during the Q&A session with the question from the audience or the other panelists. I have mentioned that Lorena and Farsam are the co-reporter of this ELI project. Lorena is a full professor in justice systems and procedure at the Complutense University of Madrid. She has been visiting professor in a number of prestigious universities, for example, just in particular, Berkeley University, Harvard University, or Stanford University. And she worked on a regular basis as an international legal expert for the Council of Europe and other international organizations. Farsam Salimi, he's Associate Professor of Criminal Law and Procedure at the Faculty of Law of the University of Vienna, with a specialization in particular in cybercrime, organized crime and terrorism, among others. And she is indeed a board member of the Austrian group of the Association Internationale de Droit Pénal. Now we're going to have some comment from the other speaker, for the panelists, in order to provide with their input, feedback, or comment on this proposal. And the first one is going to be Sveva Franco. She is a legal and policy officer at the Criminal Procedural Law of the European Commission. She has been working the Criminal Court of First Instance in Rome, and subsequently she has joined the Commission, if I'm not wrong, more than 2 years ago, and she's working precisely on this area of mutual admissibility of evidence, and she has been part of the project team as a representative of the Commission as an observer. Sveva, please, the floor is yours. If you could more or less use the next 10 minutes, even if we come back to you during the Q&A, if you want to contribute additional insight. Thank you very much. Please, the floor is yours.
Perfect. Thank you very much, Teresa. Thank you, first of all, for the invitation to speak at today's webinar. I hope you can all hear me well. Just give me signs if you cannot. Today we are indeed here to discuss and reflect upon a topic which has been long in the discussions on future developments in the EU common area of justice. And I would first of all start by congratulating the European Law Institute for the very hard and important work on this proposal, the publication of which is really welcomed from our side, since it allows to steer important discussions and exchanges such as the one we are having here today. Briefly, in my presentation today, I would like to cover 3 main points. So starting from the existing legislative framework at EU level and the recent developments in the work of the Commission, which are somehow indirectly linked to this topic. Secondly, I would like to give a brief overview of the approach taken and the results found in the study on cross-border use of evidence in criminal proceedings, which was commissioned by us and carried out by an external contractor, Milia Consulting, and which is made recently available to the public in the EU Publications Office website. I will be very happy to share the link in the chat at the end of my speech. And finally, drawing from the results of the study we commissioned, I will provide a few reflections on the text of the ELI proposal. But as for this last point, I have to make a small but important disclaimer that, as usual, I cannot comment on the proposal on behalf of the Commission, and thus the reflections would only be my personal views. So to start with, On the existing legislative framework, it is well known that the necessity to facilitate the gathering of evidence in a cross-border context and to promote admissibility before the courts was acknowledged already a long time ago, already in Tampere in 1999, following which, as a response to the EGGS program of 2005, the Commission published a green paper on obtaining evidence in criminal matters and transferring it from one member state to another with the aim of securing its admissibility. Since then, of course, a lot has happened. First and foremost, the inclusion in the treaty of an explicit legal basis, which is Article 82.2a, which allows to establish minimum rules by way of directives on the mutual admissibility of evidence between member states, of course, to the extent necessary to facilitate mutual recognition of judgments and judicial decision and judicial cooperation. Currently, we have several legal instruments that touch upon both the approximation of certain criminal procedural rules, namely the 6 procedural rights directives, as well as a comprehensive legal framework to facilitate cross-border investigations and judicial cooperation. Legislative efforts led to the adoption of rules on the European Investigation Order, the EPPO, the Joint Investigations Team, and the soon to be formally adopted the Evidence Regulation. And while these instruments, of course, do not contain rules on the admissibility of the evidence gathered, they aim at facilitating cooperation in cross-border evidence gathering and include some provisions which cover limited and partial aspects of the admissibility of evidence collected abroad. One example, and the main example in this sense, is Article 37 of the EPPO regulation, which provides that evidence presented by EPPO prosecutor or the defendant shall not be denied admission on the mere ground that evidence was gathered in another member state or in accordance with the law of another member state. Why am I mentioning this article? Because a similar approach has just been proposed also in the very recent Commission proposal on transfer of criminal proceedings, which was recently adopted on the 5th of April this year. And the proposal, which takes the form of a regulation, since it's based on Article 82.1, under its Article 20, sets out a rule mirroring basically the rule which was negotiated for the EPO regulation, for which evidence transfer from the state requesting the transfer must not be denied admission in criminal proceedings in the requested state on the mere ground that such evidence was gathered in another member state. However, to date, as we know, no legal instrument establishing minimum rules apart from the ELI proposal exists on mutual admissibility of evidence. And thus, rules on admissibility are primarily regulated by national criminal laws and widely diverge across the member states. While the topic has been looked into for quite some time now, there has not been yet a decision at Commission's level on whether and how to best act and approach this issue. But it was decided in the end in 2021 to start reflecting on the necessity of rules, and in particular to ensure the proper functioning of judicial cooperation instruments. For this purpose, we commissioned this study that I mentioned before. And commissioning this study and the final report of the study were extremely useful in identifying the existing problems of the current regulatory framework, as well as the drivers underlying each problem and the possible solutions. Since, identifying problems and drivers must be the first step whenever eventually deciding to propose legislation. The study covers a period which goes from 2010 until 2022 and is mainly based on desk research and stakeholder consultation. And it provides a legal mapping of the national approaches developed towards gathering and admissibility of criminal evidence, but it also identifies the main problems related to admissibility of evidence, which in particular were identified as, on one side, the obstacles to the admissibility of evidence in cross-border cases, and on the other side, the obstacles in the exercise of defense rights in relation to admissibility of evidence. For each problem, specific drivers were identified. In particular, it was found that the existing framework does not address situations where the rules followed by the executing state so the states that actually gathers the evidence, differ from the evidence gathering rules of the forum state. When the forum rigid actum principle applies, there are practical issues on the lack of clarity as to the procedural requirements that might to be followed, that might be applied by the other state. And finally, often there are problems as to the legitimacy of the authority involved in evidence gathering, which in one state might not be recognized by the forum state. As regards obstacles in the exercise of defense rights, also in this case, problems were identified. First of all, the difficulties in the defense ability to challenge the court decisions, which is reduced by the lack of information of how this evidence was gathered and on whether or not defense rights were actually complied with during the collection of evidence. And finally, the difficulties for the defense in making exculpatory evidence to be gathered abroad available before the national courts. And this difference in standards, of course, are also coming from the legal traditions of the member states, which differ as to the role and participation of defense in evidence gathering. Taking into account all these problems and underlying drivers, the study identified several possible policy options, going from soft law measures to legislative intervention. It was highlighted, however, that the scope and content of a possible legislative intervention can actually vary greatly, and a policy decision must be done in this regard, because a legislative intervention might be either limited to national cases or cross-border cases. It could be limited to specific types of evidence or applicable to all types of evidence. It could take the form of minimum admissibility rules or exclusionary rules. And in this sense, the ELI proposal interestingly combines some of the options which were identified in the study by including both a general chapter, which lays down principle on admissibility and exclusionary standards, and a specific chapter on admissibility of electronic evidence. I know the time is short, so I will wrap up and be brief, but I wanted to give just some quick remarks on the first chapter of the ELI proposal. In particular, first of all, on the legal basis, as this was something which was approached with attention in our study, attention must be paid to the fact that Article 82.2 offers the possibility to harmonize national legislation on admissibility of evidence. Whenever measures on recognitions of judicial decisions or judicial cooperation aspects are covered, then we fall under the legal basis of Article 82.1, and this would require a different instrument compared to a directive. So we would need to go through a regulation. This is, of course, something that one could envisage also by for instance, proposing a package of a regulation and a directive in order to tackle all the different problems in relation to this topic. And then as to indeed the minimum standards on admissibility and the exclusionary standards, of course, we are very happy to see that the draft reflects the interpretation of the European Court of Human Rights and the Court of Justice of the European Union, especially for the very important exclusionary rules which have been included. And while this is really a very important first step, it is true that sometimes in terms of a legislative proposal, my comment would be that the standards of the European Court of Human Rights might be sometimes problematic as being very general and also being created with the purpose of an assessment which happens at the end of the proceedings. So this, an assessment, for instance, on the fairness of the proceedings is very difficult to be carried out before evidence is even admitted. And then something else I noticed, but this I really don't want to take too much time, is that I found a bit contradictory the connection between paragraph 1 of Article 4 and paragraph 3. Especially with this reference to the guarantees to the fairness of the proceedings. And then on Article 6, I was also surprised to see a reference to the communication with clergymen and not instead, for instance, to doctor-patient professional privilege. And finally, as a general comment, of course, the provision on the possibility for suspects and accused to ask to have remedies, which is under Chapter 4, is essential. But I would say indeed that maybe something that I saw missing in the proposal is indeed the fact of taking into account the difficulties for the defense ability to actually challenge court decision gather abroad following the Lex Loci. And I will conclude here and leave the floor to the other panelists. And then, of course, I'm available to answer all the questions. And thank you very much again for the invitation today.
Thank you very much for these constructive comments and also the very specific analysis of the proposal in order to have later during the Q&A some fruitful discussion of the point that you mentioned. I am pleased to give the floor to our next speaker, Mr. Serge de Violet. I need to start by saying that he's going to participate today in his private capacity. Otherwise, please let me know if that is not the case. But I would like just to mention very briefly that he's director for the justice sector in the General Secretariat of the Council since September 2020. And he worked in the field of justice and security, mostly at the Belgian national level, for example, including the Ministry of Justice, the European Union Parliament representation, or other cabinets of the Minister for Home Affairs and Justice. But I insist that unless you would like to make any other clarification, you are going to participate today in your private capacity. The floor is yours. I'm very happy to hear your comment and input.
Thank you very much, and good evening, everyone. Hope you can hear me okay. So indeed, I'm speaking in my personal capacity. Thank you for saying that in your introduction as well. So what is absolutely clear is that nothing I'm going to say can be interpreted as representing the views of the Council or the European Council. So it's just personal views. I would like to start by saying that I think having a concrete proposal, so not just a study, but having a concrete proposal coming from academics provides, in my view, a very interesting way to look at this issue. It has been discussed quite a lot in the past, very often on the basis of extremely detailed and excellent academic analysis, but having here a text I think helps to look at it in a different way. So congratulations already for having gone through this adventure. I think one of the main questions is whether it is time to embark in such a legislative process, which is also a question as to whether or not member states are ready to do that now. They were not 10, 12 years ago, and I'm certainly not going to reply because, again, I'm not going to intervene on behalf of the member states. But I think that's one of the key issues, and one of the way to look at that is whether the added value is such as to overcome the difficulties, because that will often be the assessment that will be made. Before going into the instrument itself, I think it's interesting to look at where we are on EU criminal law for the moment. When looking at what is on the table for the moment, there is a clear move towards more substantive criminal law. It is quite impressive what is being discussed for the moment: protection of the environment, trafficking in human beings, violence against women, restrictive measures, confiscation, corruption, sexual exploitation. So at first sight, you might see the trend is substantive criminal law. I think it's also important to realize how much so many instruments mean in terms of implementation by the member states. So I think it's going to be quite a lot for them to transpose, and it's going to take a lot of time and energy. Has the time come to legislate on admissibility of evidence and therefore come back to more the judicial cooperation side and less the approximation of substantive criminal law? It is difficult to tell. I note two aspects which change a bit the situation compared to 12 years ago. I think 12 years ago, we were mostly discussing cases where we have an issuing state that requests, and then the information or the evidence is collected. It was not only that, of course, we already had other types of cases, but it's true that, as was mentioned, we now have different also frameworks. We have the encrochat or similar cases. We also have, as was recalled by Světlana Franko, the new proposal on transfer of proceedings. And the situation is different because you often have evidence that has been firstly collected and then afterwards is transmitted without having been requested before it was collected. Because if it is requested before it is collected, then we have this rule in the European Investigation Order instrument, which already existed in the 2000 MLA Convention, by which the issuing authority can already say, could you please apply these procedural rules so that it facilitates the admissibility in my system. But if the evidence is already collected before it is requested, or even it's not requested because it is transferred as part of the file, that part is less easy to apply. I'm not saying that is enough to convince everyone, but at least it changes a bit the perspective and the framework. Another element that I would point to, which will be important in the future, is the 10th round of mutual evaluations, which is ongoing on the application by member states of the European Investigation Order. It is usually an exercise that is quite useful at highlighting the difficulties, and so it will be important to see if it highlights difficulties in terms of admissibility of evidence. Looking at the proposal itself, and I will not go in all the details. I'm certainly not an expert as Světlana Franko is and as demonstrated right now. I will just share the main question that I have. My understanding is that the core principle is this paragraph 1 of Article 4, together with paragraph 3, but mostly this paragraph 1. I think one way to look at that, it would be interesting, is to hear from the panelists, not only how do you explain, because that's in the explanatory memorandum, but also how do you explain it in comparison with the initial proposal of the Commission in the EPO regulation, so the initial one, and then what has been adopted by the co-legislators. Because if you position the Article 4, paragraph 1 in comparison to these two, I think it raises interesting questions to see what is the type of situation that you solve and those that you do not solve with this. I note that the reference, so the principle is that the evidence has to be admissible, but there is a reference or a limitation if that would contravene fundamental constitutional principle, which, if I understand correctly, means that you still maintain a recognition of the differences between the national system and giving precedence to the constitutional law of the foreign state. So the option has not been taken, I understand, and I'm sure it was an explicit choice to say that what is important is that the evidence was collected in accordance with the law of the state, the production state, or where it was collected, insofar as that respects common standards. You added a limitation, which is that if it violates not only common standards, but constitutional principle of the law of the state where it has to be used, it can be declared inadmissible. It has, of course, advantages in terms of right of defense, but it has also limitations in terms of mutual recognition, if I can put it that way. And I would be very interested to understand what led to that option, and also whether you think that with that option, it solves most of the issues that are currently encountered. My main question is, are there so many cases where the evidence has been collected in accordance with the law of the production state, but in a way that is not fully compatible with the law of the state where it has been used. But these differences have nothing to do with the constitutional principle and nevertheless cause problem in judicial cooperation. If there are many of these issues in concrete cases, then there is added value. If not, then it certainly solves some cases, and in theory it has added value, but it might not be enough to convince member states that it warrants a negotiation and overcoming some of their initial reluctance. I will skip that part. And a big question that I have, without going into all the details, is the relation between the non-regression clause and that Article 4, paragraph 1. The way I read the non-regression clause, but I'm sure it's the wrong way, yeah? but just to play the devil's advocate. So in Article 4, paragraph 1, the evidence is basically admissible if it was collected in accordance with the law of the state where it was collected, unless it violates fundamental principle, constitutional principle. But it has to be constitutional. It cannot be just simple legislation of the law where the evidence is to be used. And in Article 13, the non-regression clause refers to simply national law, not constitutional principles. So the way I read it, and it's probably wrong, it's that it kind of cancels the added value of Article 4, paragraph 1, because it says that if it simply does not, or if the way it was collected is not in accordance with the legislation, not the constitution, but the legislation of the law, the legislation of the state where it has to be used, then it can also be declared inadmissible. I'm sure there's another way to read that, but I would be interested to have a reaction on. For the part on what is called admissibility of electronic evidence, I have the feeling that it's less a admissibility question, but more an approximation of procedural safeguards. So it's very different part of the proposal. It seems indeed very interesting at first sight, but I'm absolutely not an expert. It seems maybe indeed less controversial. And then I had a few other more specific questions, but they've already been raised. As a conclusion, I think, again, the proposal for me, I would not conclude anything on substance. I think it's a very interesting look at this issue. And I would end with another question to the panelists, which is, having had to write an instrument or proposal for an instrument, let's say, does it bring you to think a bit differently at EU instruments? And because I'm sure it must have been quite interesting to see the challenges one faces when writing. Now the General Secretariat, the Council don't write, or mostly, I mean, we still have a possibility of initiative member state, but hasn't been used in quite a while. So I think it's more the shoes in which the Commission is in, but I know that it's a very difficult exercise. And I think it's quite interesting that academics have to do that exercise. And I was wondering if it brings you to look at instrument a bit differently. Voilà, but congratulations again, and thank you for the invitation.
Thank you very much for the comment, and also for a number of questions that the co-reporter, I'm sure they will be happy to address in the Q&A session. I'm now very pleased to give the floor to our last speaker, Mr. Danilo Ceccarelli. Let me just start by introducing Mr. Ceccarelli with the latest appointment as the European prosecutor in the European Public Prosecutor Office, and also as the Deputy European Chief Prosecutor in 2020. So just starting by the end with a long expertise and background as an Italian magistrate since 1995, and always working as a prosecutor specialized in financial crime, tax fraud, corruption, and organized crime inter alia. He has been indeed an international prosecutor with the European Union mission in Kosovo, and he has also been involved in the Italian Financial Action Task Force working group, and also as a co-leader of this Financial Action Task Force project on asset recovery. So, Mr. Ceccarelli, the floor is yours. Happy to hear your comment during the next approximately 10 minutes, please. Thank you.
Thank you. Thank you very much. Thanks to the European Law Institute for inviting me, and notably thank you, Lorena, for that. So I will just say a few words about this project from the point of view of a practitioner, because that's what I am, and actually that's what the European Public Prosecutor Office is an office that is actually carrying out investigation and prosecution on the field. So we are noticing a lot of these issues that are being discussed today on our daily activities. So there's just as an introduction, actually, the most important thing I would like to say here today is that harmonization is really needed. This is the issue of admissibility of evidence and procedural rules more in general is the unfinished job, or maybe never initiated job, of the European legislator in spite of Article 82 of the treaty. So the European legislator was able to create such a complex office and body of the European Union, like the European Public Prosecutor's Office, with executive and operational powers directly in 22 member states. And I think it's about time that a regulation or a piece of legislation about evidence is adopted. Well, I'm saying that from the point of view of someone who sees that kind of problems every day in our daily activity, carrying out investigation so far, mostly carrying out investigation, but also we are starting the main trials. So we are starting to see also the trial phase, which relates to the admissibility of evidence. And for sure, I appreciate very much the approach of this proposal, which balances a lot the needs, the need of having an efficient prosecution and investigation on one side, and the rights of the defense and of the private parties as well on the other side, because of course we never have to forget the victims, of course. So one thing I would like to say also as an introduction, I'm a bit, I come from a certain background in my home, in my member states, and I really like to make a distinction between three phases when we talk about criminal procedure. And it is the gathering of elements during the investigation, the admissibility of evidence, and the assessment and the probative value of the evidence. These are three very different stages. And let's not talk about the last one, because that's for the judges and that's for the main trial, and we know about that. But it's very necessary that we make a distinction between the way what is not evidence yet, but are evidentiary elements are gathered during the investigation, and rules on admissibility, because these are two very different things. And I understand that this study doesn't want to impinge and to get into the problem related to adversarial system and the inquisitorial system, but it's very difficult to regulate something like that without talking about this topic, because that's too important. And I can tell you from the point of view of an office that is built up according to the regulation with a very much adversarial idea in mind, but that overlaps with national legislations that are inquisitorial, where the investigative judge has a lot of powers still in the investigative phase, and this is creating a lot of problems. You know, France and Spain changed their legislation for EPPO cases. Belgium did not change their legislation, and now we're having a lot of problems in carrying out our investigation when the investigative judge steps in and he decides what to do, who to send an European investigation order to, how to carry out cross-border measures, and whether to interview someone or not. That's a big problem for us. For me, what happens during an investigation is not gathering of evidence yet, because only through an adversarial process you have evidence. So this is done at the presence of the defense before a judge. And this cannot be done in the investigation because otherwise the efficiency of the investigation doesn't work. So I would really try to take into consideration these aspects very much. I will tell you like a very clear example of what is happening now. You know that there is an ongoing case at the Court of Justice as regards the PPO regulation about Article 31, and I'm going to talk about that a little bit later on. But there is a new one coming, and this new one comes from Spain, and not accidentally, it comes from what used to be called an investigative judge, and now is called a judge of guarantees of freedom, something like that. So this judge is not happy that the prosecutor can decide whether or not to interview a witness, so something very, very simple that we do every day, without the witness being able to oppose that, which is something that the witness can do before the judge, but cannot do before the European delegated prosecutor. So this judge raised the preliminary question before the Court of Justice because this judge, she doesn't like that system, right? Because they are used to have a very different system where out of the secretive phase of the investigation, the judge is really in charge. So everything is already done at the presence of the parties during the investigation. So there are really very different systems, and we cannot have common rules if we don't sort this out before. Otherwise, we don't get to the minimal standards, right? So what happens? There's a few interesting points in this proposal, but we need to start from the basics, from these, like, you know, general considerations about systemic issues. There is one thing I was that was very interesting. It's about filtering out. This term is used somewhere, right? Talking about client-lawyer privilege, but as Sveva clearly pointed out, it's not only about that. There is a lot of situations where evidence would not be admissible clearly because of other situations like classified informations or state secret or other kind of privilege between professionals and clients or situations like that. Well, filtering out this information during investigation is simply not possible. That's the way it pops up when you search a place, when you intercept telephones, when you intercept a computer, when you gather information from an electronic device, or even simply in a physical place. Because before you realize what is there, you need to read it, you need to listen to it, you need to understand it. So what we need is not a rule for filtering at the moment of gathering, is a rule for not using. But I'm not saying that this should be presented in court and declared admissible. There should be a duty of the prosecutor, and even before the prosecutor, of police, of not presenting this at all, because these are rules, there are common rules, these are common rules that everybody has to respect. So it's a bit different than filtering out at the moment of gathering. It's something that should be assessed at a later stage. So one of the most important thing, of course, of this regulation here is Article 4. In the year, I really agree with what Serge said before me. The reference to the national constitutional principles, to me, is wrong. That's going to create layers of problems, not to resolve problems. And I can tell you that from the point of view of the PPO, we have that problem every day, because the EPPO regulation makes reference to national legislation 85 times. And that's a problem that we have every day, to find consistency in the way we carry out investigation, in the way we prosecute, in the way we have to be consistent in our prosecution, in our action. And if you make too many references to national legislation, this is a problem. There are constitutional provisions that are not really about fundamental principles, but if you just make a reference to constitutional law here, then we will have a lot of differences. But why cannot we make reference to the Charter of the European Union and to the European Convention on Human Rights that is referred to in the Charter? Everything is already there. Also provisions like the that talks about the prohibition of using evidence if there is torture or violence or pressure. Do we really need that? That belongs to all of us. That's like a given, something that we don't even need to discuss. This is impossible not to act like this. That's inextricably, inherently inadmissible evidence, because before there is a crime, there is an offense, a serious offense that was committed by a public official to obtain what I refuse to call evidence, but something, you know, that someone might be tempted to use in court. Another couple of things, and this refers to Article 4.2 and to the article about legal remedies, Article 10. And this is strictly connected to the issue of Article 31 of the EPPO regulation. These kind of rules needs to be drafted better, because otherwise they create more problems than what they solve. If you talk about rules in the member states of the Lex Loci or rules in the member states of the Lex Fori, you need to decide, the legislator needs to state clearly who is in charge of making decisions, who decides if the law, if the gathering of evidence was legal or not, in which of the two member states, based on which legislation, on which rules. This is very important. We have Article 31, which is very, very badly drafted, Article 31 of the EPPO regulation, and we have a big problem there, because we don't know which law exactly is applicable and to which extent. So now it will be for the Court of Justice to decide that, but the Court of Justice will have a limited power of decision because the drafting of the article is wrong. For example, if you go to legal remedies, Article 10, you have to state which of the two judges is in charge of deciding what, who assesses the merits of the case, the substance of the case, the way the investigative activity was carried out, the chain of custody, for example, who needs to assess that, who assesses proportionality, who assesses the respect of basic fundamental rights. The first judge, the second judge, both. What if there are conflicting decisions? There is a lot of issues to really foresee in detail when we talk about these topics. Just a few words about electronic evidence, and then I will leave the floor to the attendees for possible question and answers. To me, talking about admissibility and gathering electronic evidence without making reference to the Budapest Convention is impossible. That's a very nice piece of legislation, especially the second protocol, which was approved a couple of years ago. It's a very nice piece of legislation that takes into consideration all the legal and technical aspects. And that's what we based our work on. When colleagues come and ask us how they are supposed to carry out a forensic copy, a search of an electronic device or whatever, we tell them, make reference to the Budapest Convention, because the issue of the chain of custody, which is tackled here in this proposal, it's already widely analyzed in the Budapest Convention, and I really think we need to make reference to that, because there is already a lot of answers to questions about electronic evidence. Although I have to say that I really love very much the second part of Article 3D, which gives a definition of electronic evidence. Because Article 3D says two things that are a bit at odds with one another. Article 3B and C, because it talks about electronic evidence as the evidence that is gathered in the member state where the evidence is to be used, and the evidence where in the member state where the evidence is gathered. But then at letter D, it states that if the place is unknown, the law of the place where the access to the evidence was granted is to be considered lex loci. This is a very important provision, very important, because most of the time electronic evidence does not have a place. It's everywhere. It's in the network. So that's the way it works now. The world changed completely, and you cannot really talk about Lex Loci in the same way we used to talk about that 30 years ago, or when I started as a prosecutor in 1995. It was very different. We didn't have that kind of problem. Territorial jurisdiction was a very clear concept. Now it's all blurred. And that's something that we need to take care of. And the idea that is the place of the access where the rules must be respected, that's something that I think it's very intelligent. Thank you for listening.
Thank you very much, Danilo, if I may. Indeed, you raised a point that is for me as a digital lawyer, if I may use that expression, a great challenging point, the idea that electronic evidence in a way question and challenge the traditional connecting factor based on territorial aspect, and to which extent we can apply this idea of location based on access. And therefore, I agree completely with your comment, your favorable and positive comments about these Article 3 using in letter D the connection of Lex Loci. So thank you very much for all the comment, for all the very, very insightful input. And what we are going to do now, we have around 20 minutes. What I'm going to do is we have already different comment that has been and question that has been put forward for the co-reporter. I can see that essentially they are revolving around electronic evidence related rules, around Article 4, 4.1, 4.3. Many comment has been related to that, and also Article 10 in relation to remedies. But before giving the floor again to Farsam and Lorena, we have some questions from the audience. First, some very nice congratulating messages, appreciating the project and also the harmonization effort made in the ELI project in particular. And then Lorena and Farsam, we have a long message with two questions that I'm going to read, if I may, for the purpose of the recording. The first question is, did you include the fruit of the poisonous tree doctrine? Evidence stemming from illegal evidence, therefore, so explaining what that doctrine is referring to, at least for violation of Article 3, as in the case Gafgen versus Germany. So this is the first question. The second question is, would not for Article 9 be useful to use rather the testimonial, non-testimonial theory? For example, in the case Sanders versus UK. And there is an additional comment, not a question. A reference to the Charter only in Article 4 would not guarantee enough protection. For example, under the Charter, the right to a lawyer is a relatively right, for example, in Article 3.6, but not under most national constitutions. So I hope that I read it in a clear way for you to be ready for replying or adding comment to that. So Lorena, Farsam, the floor is yours. You would like to raise additional comment or simply reply and address the question that has been put forward. Please, the floor is yours.
You want me to go forward, Farsam? Okay. First of all, thank you. This is what we really academics like, because it's discussing and getting feedback of the work, what we have done. And obviously discussion is enriching. Enriching is always a challenge, and is why we, at least me, I stayed at the university, because it's learning and continuously learning and challenging your own knowledge and your own ignorance. And obviously checking our result, our output, and having you on board was one of the best ideas, because you have introduced and raised a lot of issues. Sorry to say, but we have been discussing them, because in the panel and in the team, we were really, really very privileged to have excellent experts too. And some of them were raised, some of them not, but those which were not raised, I already thank you. I will try to address them. And second, those that were raised, we might not have been clear enough. So I will try to clarify it a little bit. No? I might forget something because I don't want to speak too much. You know how we professors are. Once we get the mic, we don't leave it. So sorry for this. But addressing the issues raised by Sveva, thank you very much. We were in touch with you and the Milieu study. I'm sorry to say, but the results were expected. So to say, we counted already on the issues that were raised by the Milieu study. So we are happy. We are happy to see that they confirm our approach in that sense, and they have kind of identified more or less. I was also in touch with some of the reporters, and the same issues that we have been discussing on admissibility of evidence for the last 20 years were more or less very well structured in this report. So confirmation is always very good. We are not surprised of that. So it's a good news. What you raised about contradiction, and obviously we discussed a lot about Article 4.1 and 4.3. For those who are not listening to us and talking about 4.1, 4.2, or 4.3 and don't have in sight that context, 4.1 says, member states shall ensure that evidence obtained in compliance with lex loci shall be admissible unless it infringes fundamental constitutional principles of the forum state. And 4.3 says, member states shall ensure that, as a rule, evidence transferred to the forum state is still submitted to an assessment of its compliance with sufficient guarantees to safeguard the fairness of the proceedings as a whole. And obviously, we agree fully with you, Sveva. We are using very general concepts, but of course, it was impossible to really define them in a more clear way, in a more precise way. So we decided that, and this was raised by most of the experts, we want to have an emergency brake, so to say. We want to have mutual recognition as far as possible, so admissibility is the rule. But the member states, in assessing or in the stage of admitting, they might be able to invoke their own constitutional provisions, because otherwise we will, and this was also comments from members of the council. Sorry, if you don't include this clause, member states in the council will simply reject this proposal. And we tried to be pragmatic. And the EncroChat case in a certain way has given us some confirmation on this, because certain member states want to check if this is really against their own constitutional principles, precisely on separation of intelligence and criminal evidence, precisely on having an enough higher threshold of probable cause or suspicion, indications of a suspicion, before intercepting a whole messenger system. And the court, the federal court in Germany has really kind of sided or left this issue aside by analyzing it from only the point of view of the European investigation order, just saying this was evident, that was already, as you put it, searched. This was already collected. We are not checking how it was collected, so it can be transferred because the European investigation order says when evidence is already there, there's no ground for refusal to comply, which does not mean that it's automatically admissible in the requesting state. And this is the question that is pending before the European Court of Justice right now, because the judges themselves are questioning, is this against our constitutional principles regarding the protection of every citizen to be intercepted in their communications, in their privacy, if there's not enough and strenger Tatverdacht, so a higher really threshold. And analyzing this issue also with regard to all the concepts of probable cause as the gatekeeper of the principle of the rule of law, as the US Supreme Court has stated, and the European Union member states have more or less in the criminal codes of procedure accepted that if there's no probable cause, high suspicion rate, fundamental principles are to be encroached. So this is why we were kind of in favor of introducing this admissible unless infringement of fundamental constitutional principles. Of course, this is curtailing the automatic or general principle of mutual admissibility. We are absolutely aware of it. We are cutting and renouncing to a certain mutual recognition principle, giving this emergency break in certain occasions, in certain situations. Why constitutional principles and not referring to the charter? The comment of Anse in the chat has put it already, because they are not equal in some member states. They even have higher standards in their constitutional law, in the constitutional case law. And this is, for example, in the right to have a lawyer present, which in many cases is, like in Spain, it's a right which is not possible to be waived. So the lawyer in criminal proceedings is to be present, and it's not only access to lawyer, as under the charter will be granted. No, so this might be a clarification regarding the scope of 4.1 and relating to 4.3. Relating to 4.3, it means the idea was, if we want to ensure a higher protection for defense rights, defense is not in the executing state, has problems in checking whether lex loci has been complied in the executing state or not. So try to provide some safeguards to the defense by preventing that the courts, when they know that the evidence that they have already collected or that they are collecting has already infringed lex loci, they don't transfer it to the requesting state. And second, in certain occasions, even if in the national state and the executing state, this evidence would not be used because it's infringed some kind of formal rule, some legislative provision, nevertheless, it could be transferred because it could be used according to the general rule if it's not the sole and decisive evidence rule. So if the fairness of the proceedings as a whole is respected. So we are not imposing the cutting the possibility of transferring evidence to another member state just because a little formal infringement in the lex loci has occurred. Because in many cases, this does not lead automatically to the absolute exclusion of evidence, but only to a lower assessment of the evidence or a higher checking of its proportionality. For example, and coming back to the cases Danilo has put forward, relating to the filtering. What happens with the filtering? If you don't filter in some executing states the computer data in the moment of accessing, and I come back to your questions, Danilo, it would not be acceptable. It would not be admissible as evidence. Stop. But can they send that computer, the mirroring of that computer to another country? And we consider yes, if then it is used in a way that does not infringe the fairness as a whole, so that the filtering is done later, for example. I'm not sure if this clarifies or not, but I can come with more examples later. I'm going quite quickly because there were so many issues raised and so many interesting issues that you put forward. I don't want to forget anyone. I come back to the filtering, Danilo, don't worry. Article 6, privileged communications. We discussed if doctor-patient and access to those communications and those files should be subject also to an exclusionary rule of evidence or not. Clergy, we found out that that's an absolute secrecy and respect secrecy in all criminal proceedings and all criminal procedure rules along European Union. So there's no possibility to make them provide that information, summon them to testify, or intercept those communications. That would be against freedom of religion, and that's accepted in all member states. Lawyer-client privilege. Lawyer-client privilege, it's not an exclusionary rule, and this is one step forward. We really wanted to go forward, and this answers your question, Serge, as to what is the added value. The added value here is that European Court of Human Rights has said this violates, but it does not say automatically this is an exclusion of evidence. This violates the Article 6 because it really impinges the fundamental right of the defense, and confidentiality of lawyer-client communications is an absolute crucial element to it, but it does not say evidence shall be excluded. And we wanted to increase, and we considered this was essential to be increased, this protection of lawyer-client privilege by introducing an exclusionary rule in this regard. But doctor-patient privilege is not recognized as such. It's subject to enhanced and stronger privacy protections. It requires a more detailed assessment of the proportionality and the necessity of the measure, but it's not an absolute privilege. Even in many countries, like in Spain, the doctor has the obligation to report on certain information he gets or she gets from the patient, precisely if there is a suspicion that there has been some maltreatment or there has been some criminal offense behind those wounds or those declarations. So this is the reason why we didn't introduce it in Article 6 and kept it to clergy and lawyer-client privilege. There are other privileged, obviously, privileged confidentiality relationships. Yes, we know. For example, in some countries, auditors are subject to the same extent to the lawyer-client privilege confidentiality, but in others not. So we kept here kind of, let's be ambitious, but let's be also realistic and pragmatic. We try to harmonize, but we harmonize at the so to say, lower common standards. And Serge, your momentum, is this the momentum? I would answer, it is never the momentum, because we have been discussing since Tampere this, Lisbon Treaty introduced it and said, please, you have the competence to regulate this, and every time it's being raised, you perfectly know, and everyone in the chat and everyone knowledgeable with these topics knows it is never the momentum. So we decided, as the EPPO has already started, it is now more evident that this is necessary. It is necessary, and for the member states to convince them that this is the momentum, you only have to talk to the practitioners. In every conference, in every webinar, in every meeting where there is no enough defense rights, we need rules on admissibility of evidence, because the protection against illegally obtained evidence cannot be left exclusively to the trial court in the assessment phase, first. Second, the same to the prosecutors. We don't know according to which rules we shall assess the compliance and the admissibility. So we are moving in an area of uncertainty that does not really help the efficient prosecution and neither the efficient defense rights. So yes, it's the momentum, and yes, since it will never be, I think EncroChat really shows that this is necessary, that we have come to a point that we have to deal with these issues, because otherwise if we cannot harmonize, and we are not going to harmonize because that would be unrealistic on the investigative measures, as was the proposal on the first regulation on the EPPO, just to have a clear set of rules on the investigative measures, and this was absolutely rejected, as you all know. Let's at least create some certainty regarding the transfer of evidence and its admissibility. What is the added value? I would say, what is the added value facing the difficulties? I would answer you with another question. What are the difficulties in accepting this proposal? Because to our mind, it's beneficial for all. Yes, it has parts that are not completely satisfactory for none of us. But where do you see the difficulties that the member states would oppose to such a text? Reasonable opposition, because some member states just oppose to everything, we know. So the added value, higher protection of lawyer-client privilege, higher protection on right to access, right to have a lawyer present during a police testimony, which is kind of elevating the Saldus doctrine to a supranational level. Higher protection regarding with what Danilo put forward regarding the standards of electronic evidence. Of course, we took into account Budapest Convention and the second additional protocol. Of course, we followed it. And of course, we checked on what was being done by the forensic IT experts. And in this sense, the Bologna project financed by Olaf was really, really very useful, because we were in touch with IT forensics and they said, this is to be done in every country. And we are following the Europol labs, forensic labs guidelines. We are following the first access to the computer device and so forth. So those standards are already there. Why not elevate it to supranational rules? So introduce some harmonization so that not international public law is followed or not followed. And we know how the infringement of these, of second additional protocol and Budapest Convention and its interpretation might differ. So we wanted to go a step forward in harmonization.
Lorena, I'm very sorry to interrupt you. Yes, because
to interrupt, and I finish. To interrupt, and 1 second only. The last one only. What happens with Lex Loci and breach of law? We realize that the controls have to be in the executing and in the receiving or forum state. National and constitutional, at one point national and 1 point constitutional, and in both sides constitutional. Danilo, I would love to enter into the filtering of computer data and adversarial accusatorial, because you know I have written extensively on those topics, and there's nothing that we like more than talking about where we have researched and written. But Teresa is very, very stringent with the time. So if she allows me, I enter into it. If not, I stop.
Lorena, thank you so much. Indeed, I think that this discussion required not only a couple of minutes, but a second webinar in order to discuss in details, and not only the question that has been posed today, but also even some questions that are pending from the audience. So as you can see in the chat, there are congratulating messages and very, very positive, as well as a couple of questions in addition. I know, and this is what I have been told, that we have to conclude on time. That is the only reason why I interrupt you. Otherwise, I was indeed enjoying very much all the replies. And therefore, what we are going to do is to conclude this session in the belief that we are going to organize, and we should probably organize another webinar in order to continue discussing this excellent proposal that has been so warmly welcomed by the audience. So thank you very much. Farsam and Lorena, as co-reporter of this fantastic project. I have had the privilege of being an assessor, and therefore have the pleasure to work with you and see your extremely quality work. Thank you, Sveva. Thank you, Serge. Thank you, Danilo. Thank you very much for having been part of this fruitful discussion and for having the time to share with you and with us and the co-reporter these insightful comments. Thank you very much, and we conclude the webinar today.